At 40:47 this morning, something unusual happened. For the fourth time in just 3 weeks, a major financial institution cut off all business ties with one of the most powerful figures in American politics. This isn't just a routine banking move. What you're about to see points to a planned, coordinated strategy, something we've never seen done like this in U.S. history. I have the internal emails, I have the exact timeline, and I have a legal memo from 2019 that warned this very situation could lead to a constitutional crisis. If you care about whether corporations can quietly shut someone out of the financial system, subscribe now and turn on notifications. The next 72 hours will decide whether this tactic becomes standard practice. Let's break it down. First, look at this document, never released publicly before. On January 3rd, 2025, JP Morgan Chase sent a termination letter. The wording sounds harmless, almost boring. Business relationship no longer aligns with institutional risk parameters. 30 days to close all accounts. On the surface, it looks normal, but here's the part no one is talking about. The letter is dated January 3rd, but the board actually approved this move on December 18th, a full 16 days earlier. That gap matters more than you think. Remember that date. We're coming back to it. 5 days later, on January 8th, Bank of America does the same thing. Same generic language, same risk excuse. But this time there's a change, only 14 days notice and no grace period. Accounts frozen immediately. Then on January 14th, Deutsche Bank takes action. No warning letter at all. Accounts are suddenly suspended. Wire transfers are stopped mid-transaction. Turu's $3 million in payroll money frozen. 47 employees don't get paid. On January 18th, Wells Fargo follows. Both personal and business accounts shut down. Access to safe deposit boxes revoked. No reason given. 4 major banks, 15 days. Not a single public explanation. But here's what they haven't told you. I have an internal email dated December 15th, 2024, sent by a compliance officer at one of these banks. Identifying details are removed to protect the source. The subject line reads, regarding coordinated approach to high risk political exposure. Now listen carefully to this line from the email. Following discussion with peer institutions, recommend accelerated timeline for account terminations to avoid outcome. This wasn't random, and it definitely wasn't accidental. And what this means for politics, for banking, and for individual rights is far bigger than most people realize. 3 banks, 1 week. The same topic on the agenda. That's not chance. That's coordination. And in the eyes of the law, coordinated action to cut someone off from the financial system has a specific name. I'll get to that in a moment. But first, you need to see the 2019 legal memo I mentioned earlier, because this exact scenario was predicted years ago, and Congress was in 2019 by a former Assistant Attorney General from the Bush administration. It was addressed to the U.S. Senate Banking Committee. The title alone tells you how serious it was, corporate coordination and the weaponization of financial services. Here is the key warning, quoted directly: if major financial institutions coordinate to deny services to individuals based on political affiliation or speech, such action would constitute a conspiracy to violate civil rights under Title 18, United States Code Section 241, and would create a private sector enforcement system more powerful than any government censorship. This wasn't a blog post or an opinion piece. This was formal testimony to Congress, warning that banks could achieve what governments legally cannot, silencing people by cutting off their access to money. Now let me show you why that warning matters today. Title 18 U.S. Code Section 241 covers conspiracy against rights. To To prove illegal coordination, prosecutors must show three things. First, an agreement between two or more parties. We have internal emails referencing a coordinated approach. We have board and risk committee meetings held in the same week. We have nearly identical termination language across four major banks. That points to agreement. Second, intent to deny constitutional rights. The First Amendment protects freedom of association. The Fifth Amendment protects property and due process under the law. When institutions work together to block someone from the financial system, they are stripping away those protections. Third, actions taken to carry out that plan. Account closures, yes. Frozen assets, yes. Carefully synchronized timing, yes. All three elements are present. This isn't a new legal idea. In 1985, the Supreme Court ruled in FTC v. Superior Court Trial Lawyers Association that coordinated denial of services by private actors can violate both antitrust and civil rights laws. The banks will say this was all independent decision making. But when you have shared communication, matching timelines, and near identical actions, independence becomes a hard claim to defend. Now, their main defense will sound reasonable. We can choose our customers. This is risk management. It falls apart when you look at the facts. If this was truly about risk, explain this. Credit rating unchanged. Rating level AA minus. Debt to asset ratio improved in 2024 compared to 2023. Default history zero in over 30 years. If the risk didn't increase, why did the accounts get terminated? Now look at the timing. No new lawsuits in December. No new court judgments. So the question becomes unavoidable. If nothing changed financially or legally, what exactly triggered this coordinated shutdown? And that's where this story gets even more serious. No regulators stepped in. No enforcement action was taken. So what actually triggered these decisions in December? This is where the selective enforcement problem becomes impossible to ignore. Bank of America still does business with clients who have criminal convictions, clients under active federal investigation, and clients with weaker financial profiles than this individual. If this were truly about risk, that inconsistency wouldn't exist. When risk fails to explain the timing, when coincidence fails to explain the coordination, only one explanation remains. This was political, and the political angle gets even darker because the pressure didn't start inside the banks. It came from outside. Start with November 2024, right after the election. 23 Democratic senators send a letter to major financial institutions. The subject line, institutional responsibility to democracy. The message is subtle but clear. Continued association with certain figures could create serious reputational consequences. Then on December 5th, progressive advocacy groups launch a coordinated social media campaign, the hashtag FagBank Responsibility. The message targets banks still doing business with so-called election deniers. On December 12th, the Senate Banking Committee announces a new hearing titled Financial Institutions and Democratic Norms. The witness list includes the CEOs of JP Morgan Chase, Bank of America, and Deutsche Bank. Then on December 18th, 3 separate board meetings, all at different banks, reach the same conclusion. You don't need to believe in conspiracies to see what's happening here. You just need to follow the timeline. And this isn't the first time something like this has happened. To understand what we're seeing now, you need to know about Operation Choke Point, because what's unfolding looks like its modern sequel. From 2013 to 2017, during the Obama administration, the Department of Justice launched Operation Choke Point. Officially, it was meant to stop fraud in the banking system. In practice, It shut down legal businesses the administration disliked, gun dealers, payday lenders, and entire lawful industries. Here's how it worked. The DOJ labeled certain sectors as high risk. Bank regulators then increased scrutiny on any bank that served them. Faced with audits, penalties, and endless oversight, banks made a simple choice: drop the clients. No charges, no court cases, no due process, just financial isolation. And the ending matters. In 2017, a House investigation concluded that Operation Choke Point violated constitutional rights. In 2018, the government settled lawsuits with affected gun store owners. The DOJ formally shut the program down. The House Oversight Committee summed it up with this finding: the government cannot use indirect pressure on banks to achieve results it could not legally impose through direct regulation. That isn't opinion, that's established law. But here's why what's happening now is even more dangerous. Operation Choke Point was clearly government-driven. There was a visible chain: government pressure, bank compliance, targeted businesses. You could trace it, challenge it, and prove responsibility. What we're seeing in 2025 is different. This version is corporate-led, which makes it harder to detect and easier to deny. Here's the contrast. Back then, government pressure, banks comply, targets are cut off, clear cause, clear accountability, eventually shut down. Now, advocacy groups apply public pressure, politicians issue indirect warnings, banks claim independent judgment. Targets quietly lose access to money. Same result, no clear fingerprints. And that evolution is what makes this moment far more alarming than anything we've seen before. There's plausible deniability at every stage. That makes coordination harder to prove. But the end result is exactly the same: financial exclusion driven by politics. And this is why it's more dangerous than government censorship. When the government silences you, the First Amendment applies. You can go to court. You can demand due process. You can challenge the action. But when corporations do it, they hide behind the label of private business decisions. And when those corporations control access to the financial system and act together, you've created something far more powerful than any federal agency: a private censorship machine. Here's the constitutional problem. Under the state action doctrine, private companies aren't normally bound by the Constitution. They aren't government actors. But, and this part matters, when private entities act because of government pressure, encouragement, or coordination, their actions become state action. That's settled Supreme Court law. The legal test is simple. Did government officials push or encourage private companies to do something the government itself could not legally do? Now look at the evidence. A Senate letter in November, a threatened committee hearing in December, coordinated bank action just days later. That's not independent business judgment. That's outsourced censorship carried out through corporate middlemen. And it gets worse. I now have sworn testimony from a bank insider who says the quiet part out loud. The source is a former compliance officer at one of the banks involved. The name is withheld. The statement was filed yesterday, January 20th, 2025, as a sworn affidavit with the House Judiciary Committee. Here's what that testimony says. During the December 18th Risk Committee meeting, the bank's chief legal officer stated, "We need to act before the Senate hearing. If we are the only bank still doing business with him when we're called to testify, we will be destroyed." The whistleblower then asked what specific financial risks justified the decision. The response: the risk isn't financial, it's reputational. Our shareholders don't want to be linked to political controversy. But the most damaging statement is this: I was instructed to draft a termination letter citing institutional risk parameters and told explicitly not to mention political factors. That language was coordinated with outside counsel advising multiple institutions at the same time. That last line changes everything. One law firm advising competing banks, identical wording. Simultaneous action. That's not coincidence. That's coordination. And legally, that lands squarely in antitrust and conspiracy territory. The banks will deny this. They'll attack the source. They'll claim bias or personal grievance. So let's move past testimony and look at the hard evidence. What's actually happened in the last 15 days? Across multiple entities. 23 million in payroll funds frozen. 47 workers missed paychecks on January 14th. That's not a temporary problem. Failure to pay wages violates federal labor law. Lawsuits are inevitable, and they'll succeed. Next, vendors, 807 million in unpaid invoices. Contractors preparing legal action. Commercial leases slipping into default. Equipment leases being seized. This business was profitable and fully operational on January 2nd. By January 19th, it couldn't function at all. And if this is politically driven, the consequences go even further. Campaign operations can't buy advertising. Staff resign because paychecks aren't guaranteed. What you're watching isn't market discipline. It's systematic shutdown, and it's happening in real time. Event deposits are lost because wire transfers don't go through. Fundraising platforms shut down because you need a bank account to accept donations. In 2025, you cannot operate without access to banking. You can't pay employees. You can't receive money. You can't even meet tax requirements that demand electronic filing. This isn't an inconvenience. It's economic execution. And here's what almost out, this doesn't just affect one individual. It creates a precedent that should alarm every American, no matter where you fall politically. If banks can work together to cut off a political figure, the next question is obvious: who's next? This isn't a theoretical slippery slope. It's already unfolding, just not always in places people are watching. Category 1. Political dissent. Today, it's a controversial public figure. Tomorrow, it's activists, journalists, or protest organizers. The standard becomes simple: your views don't align with our corporate values. Category 2, legal, but unpopular businesses. This is already happening. Gun manufacturers, ongoing. Cryptocurrency companies, getting worse every month. Cannabis businesses, even in states where it's legal. Religious organizations with unpopular social views, all lawful. All increasingly pushed out of banking. Category 3, and this one hits everyday people, individual, wrongthink. Social media posts a bank doesn't like. Donations to causes flagged by compliance teams. Associating with people or groups deemed controversial. China enforces a social credit system through the government. In the U.S., we're quietly building one through corporations. And here's the difference. You can't vote corporations out of office. This isn't fear-mongering. It's already happening. Real examples: in 2022, the founder of a cryptocurrency exchange had 9 banks close his personal accounts. No charges, no investigation, no explanation. His business was simply labeled too controversial. In 2023, PayPal froze $500,000 belonging to a conservative nonprofit. The reason given was a violation of acceptable use policy. Their actual activity, advocating for parental rights in education. PayPal reversed course, but only after a lawsuit and intense public backlash. In 2024, a gun rights advocacy group was denied merchant services by 6 different payment processors. Their offense was advocating for Second Amendment rights. This isn't speculation. It's a pattern. and it's accelerating. Now let me show you what happens when someone pushes back and why the legal fight ahead could permanently